Education Department has until the end of March next year to vet current employees in all public schools against the National Child Protection Register. The order is part of an agreement reached under a new court-approved settlement between the department and the Teddy Bear Foundation, represented by Section 27. Their application sought to ensure that anyone found guilty of sexual misconduct or deemed unsuitable for work with children is reported, added to the register, and prevented from working in child contact roles. For more on this, we're joined by attorney and Section 27 Education Rights Head, Zinat Suji. Zinat, good evening. Thank you so much for your time. Really do appreciate it. What are the details of this out-of-court settlement, Zinat?
Sure. Thank you so much for having me, Oliver. So the settlement agreement that we reached with the Department of Basic Education and the Provincial Education Departments is that they conduct the vetting of all employees within the education system by the end of March 2027. So the reporting that they are also then required to provide Section 27 with quarterly reports together, and the DSD of quarterly reports of the progress that they've made with the vetting. Part of this is that they need to include reports from the Educator Labour Relations Council and the South African Council of Educators to see how far have they gone with all of their disciplinary processes that they can also include in their reporting to us. So this will be what is required of them. We are hoping that progress would be made and that the deadline is met by next year.
Yeah. Mechanistically, do you believe that the department has the capacity to carry out this out timeously, given that this isn't their first attempt at getting the vetting underway?
I mean, it's an undertaking that they've made by them. You know, it was agreed, and they said that would be a reasonable time. I'm not sure if it's going to be met. We'll have to see how the progress goes throughout these months, and hopefully by the end of this year we'll be able to assess whether it is doable or not. But right now I think it's something which they've undertaken to do, and they are aware that this has been made an order of court, and if they fail to do so, we'll have to return to court.
Yeah. Importantly here, Zinat, you know, and I think we need to speak about the implications of the failure to do this. What sort of recourse beyond the ordinary criminal court would families have if their child had been violated by an educator and or an employee of a school who previously or who would otherwise have been filtered out by the vetting, who seemingly has not been as a result of a failure by the department to carry this out? Would there be any sort of civil liability beyond that?
Yes, of course. I think that it depends on case-by-case basis, but I think that there has been a case actually where I think it was a 2017-2018 matter of CS versus Swanepoel, where the learner who was violated and there was no vetting done took the department to court and actually got damages for the negligence of the department. So there is definitely civil liability that a learner or parents of a learner would be entitled to. You know, this is negligence on the part of the department. So there's civil processes would be the most suitable or appropriate remedy in that regard. In relation, I mean, with criminal proceedings, it has to be against the educator themselves or the person who has committed the sexual misconduct. So yeah, I think that there is definitely some kind of civil recourse in relation to negligence.
If the department fails on this out-of-court settlement, which is now an order of the court, Zinat, what would be the consequence and recourse of that? Would it be contempt, or would there be a different set of procedures that have to kick in?
So the settlement agreement makes provision for further engagement first, and then obviously to approach the court for the possible recourse. It could be contempt, or it could be depending on what happens and where, what would be the failure, in order for us to then be able to see what the appropriate recourse would be, depending on the failure of the department.
Yeah, well, Zinat, we're going to have to leave it there. Thank you so much for your time on this. Really do appreciate it. Zinat Suji is with Section 27. She's the head of education rights and attorney with the organization. Let's take a short break.